ALS hearing is an administrative license suspension hearing. The purpose of that hearing is to challenge the suspension to your driver's license. If you get with an attorney within 7 days, that attorney can request that hearing. Now, the purpose of that hearing is to determine whether the officer followed the right procedures, whether your rights were violated, or if there's any defect in the way your test results came out. If you can identify some problem with your test results or some problem with the way the officer went about his business, then you can prevail at that hearing. The thing about the ALS hearing is it's an all or nothing proposition, which means if you win, there's no suspension at all. If you lose, the suspension happens just like anybody else's suspension, which is 90-day suspension, 30 days at the front end, you can't drive at all, 60 days at the back end, you can drive for work purposes. The ALS hearing is a telephonic hearing. At the hearing, there's going to be a hearing officer or a judge, and that hearing officer is provided by the Department of Transportation. You and your attorney will have an opportunity to be present by telephone, and you'll have the opportunity to subpoena evidence. You'll subpoena police reports, you'll subpoena audio and video records, and most importantly, you can subpoena the police officer to testify. And there are some benefits to having an ALS hearing. The first benefit is you get kind of a preview of what the evidence is going to be against you. You get that pretty early on. But perhaps the biggest benefit is you get the opportunity to put the officer under oath, and you get to cross-examine him before you're ever in front of a jury or you're ever in front of a judge, and you get to see, what his statements are going to be. You get to tie him to a certain set of facts that then you can disprove, and it helps immensely in the criminal case that comes along. The hearing usually lasts between 15 minutes and a half an hour. Sometimes they last up to an hour. And in that time, there will be an opportunity to present evidence. There'll be testimony by the officer. If your attorney feels like he needs testimony from you, you may be put under oath and testify. And then finally, your attorney will get a chance to make arguments and explain why the Department of Transportation shouldn't suspend your driving privileges. A BAC hearing is a hearing for a test refusal. So if the officer demands that you submit to a breath test and you refuse that, instead of an ALS hearing, you'll have what's called a BAC hearing. Now that is different than the ALS hearing in a couple of respects. First of all, it's in front of a judge. It's not in front of an employee of the Department of Transportation. We'll go down to court, the judge will come out and be on the bench, and we'll have an opportunity to present our case. The second way it differs is that in the BAC hearing, you have a chance to show why you refuse. So it's actually kind of a two-part hearing. First, the state has to prove that you in fact did refuse. If you refused, you have the opportunity to say, well, I had a good reason to refuse. The classic example is asthma. I just couldn't breathe. I was coughing too much to submit to the breath test. I couldn't sustain a breath that long. I didn't mean to refuse. I just physically couldn't comply with the test. If you can show either that there was no refusal or that you had a good reason to refuse, then you'll prevail at that hearing. The other thing that you should remember is that a BAC hearing has different consequences. A refusal in Idaho carries with it a mandatory 1-year driver's license suspension. It carries with it a $250 fine. So had you taken the test and failed, the worst that happens is you lose your license for 90 days. A BAC hearing, it's a 1-year suspension, and that's absolute. So there's a different way the hearing's conducted. There's different consequences that happen because of a BAC hearing. But BAC hearings, you need to remember, only for a refusal of a breath test. Finally, you should know that in some instances, the police will, even though you're refusing a breath test, they will forcibly take blood from you. It's called a forced blood draw. And unfortunately, the case law in Idaho is that, at least at this point, somewhat legal. It's been challenged, and the Idaho Supreme Court has upheld that. That being said, it leads to the question in the BAC context is, if they got a blood draw, did you refuse an evidentiary test? And so that's a good argument to present to the magistrate judge that's hearing your case, is that, well, while I didn't take the breath test, they ultimately took a blood draw, and there was a test, so I shouldn't be held accountable for a refusal. I shouldn't be suspended for a year.